Ladies and gentlemen, let's talk. We Lepak and Chill on the TLC podcast. Yeah.
Okay, welcome once again. Good evening, everyone. Welcome once again to Talk Lepak Chill podcast. And today we are going to be live once again. Okay, this time around will be an English podcast. Okay, so as I mentioned earlier, and also at the start of the initial podcast on Spotify and Apple Podcast, and also on Facebook Live. Okay, we are going to have this in Malay, some episodes in Malay and some episode in English to actually cater to the different community and the different segment, okay, who are actually watching, the viewers of Talk Lepak Chill podcast. And my name is Helmi once again. Good evening to all of you. And today's topic, okay, will be a topic that a lot of people are struggling to understand better on about how do you recover debts owed to you. And so without further ado, I would like to invite first our guest. Okay, and we have two guests today. One is our guest moderator, Ms Haryani Othman. Hello, Haryani.
Assalamualaikum. Hello, how are you everybody?
Waalaikumsalam. Okay, she's a manager of IRB Law LLP. Am I right?
Yes, I am. Thank you.
Okay, so welcome to Talk Lepak Chill. And next we have our main guest, main star of the night, okay, who will chill with us tonight will be a lawyer from IRB Law, Mr. Quek, Liuying. Hi, Liuying.
Hello, Helmi. Thank you for your kind word. Thank you for inviting me. I'm very happy to be here. I hope to answer as many questions as possible.
Okay, and thank you to both of you for making time, and hope you all had both of you had your dinner already.
Yeah, we will after this.
Yes, thank you, honey.
Okay, and right now we'd like to inform you that if you would like to ask any questions, okay, you may actually just type on the comments box, okay, which is on the Facebook Live itself, and don't do a watch party. If you are watching, sharing it as a watch party, okay, we are not able to see your questions, so you need to share using the share button on the bottom left hand corner, okay, of this live streaming video. Okay, without further ado, we are going to proceed straight to the first questions, and maybe Liuying and also maybe Haryani can for a start, okay.
Yeah, I can start and by saying a bit more of what this topic is about, just to get us a bit warmed up, and maybe some of our audience just walking, just streaming in and thinking like, what are we talking about? So, guys, welcome. We are on Talk Lepak and Chill podcast, and representing IRB Law, and also moderating it as myself. I have with me, like what Helmi said, my very good colleague, Mr. Liuying. You can call him Liuying, and then he is one of the lawyers of our firm. And I don't know whether it's good for him or not, but he's actually quite an expert in getting debt recovered. So yes, so he's in this. He's in civil litigation department, and then every time we want help with something that has got to do with debt recovery, he's the go-to man. So thank you for doing this with us. So that is, I mean, everybody know what that is lah. Okay, what is it?
Yeah.
It's never a good word. Yeah, it's never a good word. And then if let's say if I can speak a bit of Malay, hutang. Everybody knows what hutang. We actually have a very famous song on that title itself. So remember? Yeah, so when we are in a pandemic situation now, recession, things are hard for everybody. Things are hard for businesses. things are hard for individuals. So you will see a lot of people, hurrying to get what is owed to them as a
Hmm.
person and also as a business. However, everybody is doing it the correct manner, because some of them use collectors. It may not be legal, you know. Um, they make, some of them to go and make police report, but after what they don't know the rules, they don't know what are their rights, what are their obligations. So here is Liuying to speak about it. I will start with getting him on with some preliminary questions. So, Liuying,
Yes.
can you maybe let us understand the type of debts that people usually
Mm,
get involved in or entangled in?
Sure, honey. Okay. Thanks for the very beautiful introduction. And yeah, the first question itself is actually a very wide question, but for the purpose of this talk, I will just narrow down. So yes, for that, generally you have a secured debt, unsecured debt. I will not go into so much about secured debt. Secured debt is basically like a mortgage, you see. So if you owe the bank money, you don't pay, the bank take back your house. So there's some kind of a collateral that is secured debt. For the both of this topic, we will focus more on unsecured debt. And when it comes to unsecured debt, as the name suggests, you're unsecured. So your position,
Pay the bank
yes,
take back your house.
fortunately in law is not very strong because there's nothing to secure this debt. And when it comes to unsecured debt, yeah, then mostly there will be from, especially in our firm perspective, business debt and a personal debt. Personal debt, I owe you, you lend your friends money, you lend your relative money, they don't pay you, and that itself is a debt already. And of course, when it comes to business debt, you bought something online, you provided your service, you can be a home business owner, especially now during COVID. I understand many people start to maybe bake your own kueh lapis, etc. You
Mm-hmm.
delivered already, the person don't pay. This itself is an unsecured business debt.
Uh-huh. Okay,
Mm.
so when you say about unsecured debts, okay, so
Mm.
basically when you say about secured debts, that includes mortgages and also
Yes.
bank loans. Okay, so it's easy for the creditors, right, to actually recover the debts that has been owed. But then how about unsecured debts? What
Mm.
are there like no different ways for them to actually recover all these debts?
Mm. Yes, there are definitely ways, procedures under the law to help unsecured debtor to recover the debt. It's just that yes, compared to secured debtor who already has a collateral, an unsecured debtor unfortunately finds him or herself in a poorer position, I would say. So yes, from our experience, you generally, of course, before you go to a lawyer, it really depends on your own perspective as well. Really, how much do you want to recover, and do you think it's worth it to sour the relationship? Have you tried? You know, this person already blocked you on WhatsApp, blocked you on Facebook, everything. Then you think that okay, I have no choice anymore. I have to go to a lawyer. So the first step, as I can imagine, what most lawyer will do is to assess your situation. Uh, how much is the amount being owed? Of course, look, we need to understand. Yes, if you have an IOU, okay, the evidence is very strong. If you were to sue in court, then of course you can say that most likely you are going to win. But let's just say the amount is only $1,000, 1,005. Is it really worth it to engage a lawyer to spend your time, and then in the end you don't really know whether you can recover? But of course, that's not to say that a lawyer role is unimportant. So you it helps to have somebody who understands the procedure to explain to you. And we usually go by a letter of demand. Okay, that is usually a prerequisite to suing somebody. A letter of demand is simply a letter to tell the other party, look, this is your last chance. I'm going to give you one final chance to pay me this debt. Okay, but what we hope to achieve usually is that some people, so you never know, debtor who think that this one my long-term friend won't sue me on, won't go to lawyer, no have to worry. Sometimes people perspective will change once they see a letter of demand, and they will say, "Oh no, it's getting a bit serious now. I don't want to be sued," and there will be some kind of psychology. Of course, we hope, and you never know also because this debtor, depending on what kind of industry he or she may be in, he or she may be very worried to get sued. Okay, so letter of demand is your last chance to say, look, this debt have been very outstanding. I'm very patient with you. It's time that you pay up. If not, I'm going to sue you. Yes. So generally, yeah, the first step is letter of demand.
Okay, I'll just stop there for a while. I'm hearing a bit of background noise. I don't know where it's coming from. Maybe can see whether any of us has got anything turned on nearby. Can just shut down the sound.
Just
But I'm just gonna repeat what Liuying said. So the first step is when you know that somebody owes you a debt, and he has spoken about secured and unsecured debts, and I'll just put it in another words. I think for most of us here on Facebook, we are quite concerned that it will be debts that are owed from like a friend to a friend, something, or I supply you like so much items, and then you're supposed to pay me back, you did not, or you promise that you're gonna use my money for, let's say, your car loan, but then later, even when your car is being sold, nothing comes back to me. So everybody, the first step that you should do according to Liuying is go and see a lawyer and send what we call a letter of demand. As you can hear it, as the word says, it's actually a letter where you demand the person to actually pay you back. Okay, in this point, at this point, right, I want to just give a little bit of suggestion or reminder. When you give out money, or when you are the creditor, like, right? So somebody, like, let's say, help me, you want money from me, and now I'm giving you the money, right, as a loan. Please make like a bank transfer or a check payment, or even if you don't know how to do a simple agreement, do that, or have him message you an acknowledgement and stuff like that, so that there is proof of that money being transferred from you to the person who wants to borrow. Am I right, Liuying? Correct me if I'm wrong.
Yes, that is correct. That would be a very good safeguard.
Okay, but then I have a question. Okay, what if because sometimes we have friend for maybe so many years. I trust you, you trust me, but then we don't make an agreement as what Haryani have already suggested. So without this agreement, how the other party is able to actually come out to go to the lawyer to actually for the lawyer to issue a letter of demand? Is it still possible or not possible?
That is still possible. Thank you, Helmi. That is a very common question that we face. You see, at the end of the day, of course, if you have an IOU, you have something written, just like anything in life, it makes things clearer. Going to the court, of course, is easier to show the judge, look, I have this evidence. Notwithstanding that, even if you do not have anything written, that is fine. And of course, I trust that currently the advance in technology, all of us, you PayNow, internet bank transfer, there will be some digital footprint of you transferring money to the debtor. Okay, so this itself is usually sufficient to show that yes, this person has received your money, And of course, in the worst case scenario, when you don't have anything at all, then yes, that will be a bit of a sticky situation going to court. But that will not prevent us from writing a letter of demand, because at a letter of demand stage is still not before the court. We don't have to produce any evidence yet. So it's really just as what Hani and I have been saying, it's really your last chance to pay up before I sue you. So even if you don't have evidence at this stage, yeah, fear not. There's still something we can still send a letter of demand.
Mm-hmm.
Thank you so much. I'm going to let Liuying go through the process of what happens in a letter of demand and all that. But
Mm.
touching on IOU, don't worry. We're going to get to that. Like when you do an IOU, what are we looking out for and how
Mm-hmm.
IRB law can help? So there is a question. Hi, sir. How can I convert my unsecured debt to a secured debt? Let's take this question first.
Mm.
Okay. Thanks for the question. But unfortunately, there isn't much way for you to convert an unsecured debt to a secured debt. The reason being, okay, secured debt. Long story short, it's just that you have something as a collateral. So before I lend you money, you have already given me something in possession. It can be your jewelry or anything valuable. The moment you don't pay, okay, I will sell this jewelry, or this jewelry belongs to me. Okay, so yes, to make things clear, if you lend me $500, okay, you chose not to take any security in return, that is an unsecured debt to begin with. And no, unless for some reason this debtor willing to give you something in return thereafter, then, which is very unlikely, then there is no way you can convert this unsecured debt into a secured debt. I hope that answers the question.
It does. It does. Thank you. Okay, maybe before I go to his second question, I'm gonna just continue from your letter of demand. So you go to a lawyer, and then after that, the lawyer, okay, we got your proof, we got the person's name and all that, and the address. Okay, Mr. So and so, please give back Haryani Othman's, debt that you owe her. $20,000 by such and such a date, failing which we're gonna take legal actions. Two questions here. Now, what if they never come back, or they just keep quiet, or they refuse to pay back? What can happen after that? But let's say they come back to you. They come up to your lawyer and say, I don't have $20,000 now. Can I pay 500 a month until it finishes? What happens then, Leong?
Sure. Okay, I will answer the second question first. Of course, when they come back, that itself is a promising sign already, because in our experience, unfortunately, there is still quite, I would say, a fair bit of number of debtor who will ignore the letter of demand. So if you can trigger a response, that actually is a promising sign already. Then of course, we were talking about 20,000. But it seems that 500 a month will take quite a bit of time. So at this juncture, then we will speak to client, of course, to take their instructions and say, okay, look, he or she willing to offer you 500 a month, but it seems that it will take very long to recover. So are you willing to accept? If not, do you have any counter proposal? So this is our job as well. We lawyers act as negotiator as well. We don't just, as what you see in drama, go to court, sue people. A lot of times it's about the soft skills as well. So we will recommend to you that what we think, our suggestion, will be a fair amount that you can accept. Of course, if you can accept, then you save the cost as well, because you don't have to sue this person. And of course, depending on your relationship with this person, you may be able to salvage a friendship or long-term relationship by accepting this offer without going to court. So, of course, if this person doesn't respond at all, which is the first question, then you need to sit down with your lawyer again and decide whether do you want to sue. And when you want to sue, it will start with a bit of summons and with a statement of claim. So all these documents
Maybe I
will
can stop you there for a while. This is the second question that our friend Mr. Joe Hamid asked.
mm,
Our what if my friend borrowed money from me 7 years ago? Can I sue him? We will
mm,
talk about the 7 years ago thing in a while, but now you have to decide whether you want to sue. So what does it take? I mean, when laymen, right, like a lot of the people that I know actually ask me, when you sue, you means what? Like go to court, like fight, like they see in the drama, like Liuying said. Actually, it's not so dramatic. It's very administrative in a way. So Liuying mentioned first you have to start with filing or writing out a writ of summon and a statement of claim. So that is the start of your journey towards the suit. That's what he said. So now we are coming into the legal proceedings already. So if you don't understand or you have other questions, even help me, feel free to just cut us so that we can have this done part by part. So can we continue, Ami?
Yeah, sure. You can we can continue. Okay, so thank you for Fazal for asking this question. If you have more questions, you may always just comment on the comment box. If you want to remain anonymous, okay, you can actually DM us on Talk Lepak Chill inbox, or even you may DM on Haryani Osman's or even IRP Law Facebook page if you want to remain anonymous, and we will try to address the questions that you would like to ask Liuying over here at Talk Lepak Chill. Okay, maybe the Sun Haryani is already informed us that you are going to share with us on what we need to write on the IOU or anything to create a transaction, a formal agreement transaction between the debtors and the creditors if you are having unsecured debt. So maybe you are able to share with us what
I
are
think
the
both have to be later, Ami, because that one is actually before proceedings is done.
before
So
proceedings.
now we're talking about the legal proceedings. This actually mean the debt dah jadi pun, hutang tu dah ada. So
Okay.
we suing the person, because when we send the letter of demand, they keep quiet. So when they keep
I
quiet, there is an option of you going to court or suing them. So
mm-hmm.
that's where the journey is gonna be. So the writ of summons is done, the statement of claim is done, and it is being served on him.
Mm-hmm.
On the other side, the person who owes you the money, right, is served on him. What is the implication? What does it mean if he were to come back and say, I actually never owe you, or maybe we shouldn't say that, but okay, maybe if there's two situations here, what if they really still keep quiet, or they
Mm-hmm.
defend themselves and they say I got no money, or I'm
mm,
already bankrupt. So maybe these three situation: no
Mm-hmm.
money, bankrupt, keep quiet.
Uh-huh. So does that mean that even though how much you owe, if you write to it's not 100% possible that you are able to recover the full amount due to these reasons?
Yes, the general answer, yes. As long as you're unsecured creditor, there is no 100% guarantee that you will recover your debt. But of course, if you do nothing, then you definitely will not recover anything. So, in our experience, quite frequently we have managed to recover. It's a matter of luck as well. Of course, then just a simple letter of demand, we have managed to recover up to a few $100,000 before, and there will
Mm-hmm.
also be situation where you took all the time and effort, you pursue all the way, and you recover very little or nothing. You make the person bankrupt. So, okay, out of the three questions by Hani, I will answer the third one first because it's very straightforward. So, even before you send letter of demand, ideally your lawyer should have done a bankruptcy search on this person first, because once this person is bankrupt, then you cannot sue this person without the permission from the official assignee. So I will not go in depth, but in short, once a person is bankrupt in Singapore, he, in a way, you can say that he no longer control his own assets. So all his assets will belong to will be under the control, the purview of the official assignee. So when you want to sue this person, you also need to seek the official assignee permission. But generally, what you do is that you will file a proof of debt against this bankrupt person. So the more common scenario will be, yes, if this person, once you already commence legal proceeding, this person still does not do anything. Okay, so once it was being served, okay, you have 8 days, okay, to respond. So this person as a defendant, now this is called, he or she is called defendant already because you have sued him already and you are the plaintiff, okay. So the defendant will have 8 days, okay, to file this thing called memorandum of appearance, okay. This thing needs to be filed in court. So you also, on the flip side, as a defendant, you can do it yourself or you can engage a lawyer, okay, to do this for you. If you do not do so within the 8 days, okay, then the plaintiff is at liberty, okay, to file the default judgment against you. So default judgment, as the name suggests, is a judgment given in default, okay, because the defendant never even filed a memorandum of appearance to tell the court that I want to contest. Okay, so the good thing from the plaintiff creditor perspective is that once you get default judgment, the first stage of the battle is won. Okay, so you will have, take for example, you sue for $20,000 based on the IOU. Okay, so right now there will be a official judgment, this default judgment, to say that there is a judgment debt of 20,000 which this person must pay to you. Okay, so thereafter you at least have the option to start enforcement proceedings. Okay, I will, if there is time, I will go into details later on enforcement proceedings. So as per the second question that Hani asked, what happens if this person shows an intention? I take it as this person filed the memorandum of appearance to tell you that, look, I am going to contest this claim. There is problem with this IOU, or I don't owe you any money, or generally the most common scenario that we see when it comes to those providence of services kind of debt. They will say, oh no, you didn't give me what I ordered, your service was poor, etc. I'm going to dispute the debt. So again, depending on what is the defense that this person filed, things may get complicated. Of course, if you need to move towards the litigation setting to all the way to trial, then of course it's going to cost more time and money. But this is something that I think most people should know, is that even the court right now, they are rolling out more and more mechanism for people to settle their dispute without going to trial. So take for example, if your case is below $60,000, okay, that would be in the magistrate court, and there are mechanisms to sort of compel you to undergo mediation. So again, like what Hani has touched on earlier, the life of a lawyer is actually not as dramatic as what the TV show. And so a lot of times, actually, especially when it comes to very straightforward debt, the kind that is evidenced by IOU, or the person quite clearly admits that I owe you money, I just don't have money to pay you now. Okay, so these sort of cases, yeah, generally, it's not very cost effective to go all the way to trial. And even if you were to sue, most likely, the majority, I would say, such cases will settle at mediation.
So let
Okay.
me just briefly summarize what he has just said. So you have sued, you allow a few days, I mean a number of days for the other side to say, okay, fine, I will defend myself, or I will come back with an offer, or stuff like that. And then when we say that whether it's worth it or not to sue this person, right? You have a few things to think about. I mean, you have to think about your lawyer's cost. I mean, suit is different from a letter's cost, and you must see. Okay, like let's see if your lawyer already told you, okay, he's a bankrupt. Chances are you're not gonna get your money back so soon and stuff, or even at all. Then to pay like a couple of thousands of dollars to go to court just for the judgment that you don't cannot and cash in a way. Um, it won't be smart to do that. Of course, we are also looking at the amount. If the amount is like $20,000 or even millions or even hundreds and thousands of dollars. We have done debts millions of dollars. In fact, then your few $1,000s is not gonna matter because you want that $1 million back. But don't go to court for like $50, $100. Don't lah, don't like that. You I mean, I know IRB give free first consultation, but if you tell us like, oh, because he owe me $50, the lawyers won't do that, but I might give you like this eye. We have a few questions coming up. But we will tackle that together. I think about looking at the number of questions. It's not is the funny thing, this question doesn't come on our comment section. It's actually
Yeah,
coming from my messages. Yeah.
yeah. And I also have one question here
Yeah,
that
maybe
came.
we can do the question like let's say in another like 8-9 minutes.
Can.
We will let Liuying answer two more. Continue two more things. If you
Mhm.
have the judgment and all that, what happens if really the person really, 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 really don't even bother to pay or cannot
Mm,
pay? Briefly, maybe about 2-3 minutes, Liu Yong, explain to them
mm,
with the judgment that you have that orders the other
mm,
person to pay you back your money, but they couldn't or they
mm,
are not doing it. What can be done? It's called the enforcement proceeding, but maybe simplify it, like what are the options they have.
mm. Sure. So enforcement basically, yeah, is the second stage of trying to recover your money. Okay, I will start with the most draconian one. That is to say, you make the person a bankrupt. Okay, so historically, okay, it was 15,000. So as long as a person who owes you more than 15,000, at least 15,000, okay, you can go to court, okay, and make this person a bankrupt, okay. But due to COVID, currently is it has it has raised to 60,000, okay. Then
Hmm.
I understand that I think after October 19, it will revert to 15,000.
15,000.
So generally, yes, again, depending on what industry is this person in. For example, your debtor could be somebody, especially somebody who works in the financial institution. Okay, so insurance agent, property agent, these people they cannot become bankrupt. So once they become bankrupt, they will lose their job. And of course, bankruptcy comes with a lot of stigma. You cannot travel overseas without the official assignee's approval. You are basically serving a financial jail term, I would say. So you cannot freely enter into contract. You lose your financial freedom. Okay, so some people may be wary of that, so they are scared. So once there are quite a number of cases that we have done when we reach until the bankruptcy stage, okay, we file for bankruptcy already, then we see a response. Then they will come back, sorry, can you allow me to pay installment or what, or they try to pay. Okay, then of course concurrently you can also what you should start with is this thing called examination of a judgment debtor, EJD in short. So for EJD, you take out a summons, so you summon this person to court. Okay, the purpose of EJD is to find out what are the assets that this person have. Okay, so uh, this person need to give evidence under oath. There will be an affidavit for this person to affirm. So at least, okay, the idea is he or she cannot lie. Okay, he has to take all the assets. So with all these assets, then you go and decide what is the next best step for you to recover. Okay, I will focus a bit more on what we call garnishee proceeding. proceedings, okay, because it's generally the most effective one. Garnishee proceeding is basically your debtor. Okay, let's call your debtor B. Okay, let's say C owns B money. Okay, so what you do for Ganeshi is that you apply to the court to tell the court that there is a debt due from C to B. But instead of C paying B, C will pay me. Okay, and the most straightforward case usually in such a scenario is that C is a bank. I think most lay people don't know this, but actually your relationship with your bank is that of a debtor and creditor. Okay, you are actually a creditor to your bank because the money in our account is payable on demand. You go to the bank, you write the form, you fill out the form, they have to pay you your money. It's your money. Okay, so that is how it's a debt. So when we use ATM to withdraw money, okay, that's what we are doing as well. So the most common way for enforcement proceeding, and I would say one of the more effective ones, okay, is to do garnishee on this person's bank account. If you have the bank account of this person, this is what you should generally consider first. And of course, the flip side is we don't know how much is in the bank account. Okay, so just like again going back to the overarching picture is that end of the day you remain unsecured creditor, so there is always a risk. Okay, of course, if you spend a bit more, you take a garnishee proceeding, and the debt in the bank account is enough to meet your judgment, then good for you. You have successfully recovered your debt.
Mhm. Okay, so there are a lot of terms that maybe some of the viewers might be confused.
Sure.
Even I also try to catch up with the some of the terms. So if you are really unsure about the terms that Liuying have already shared, okay, I've already pinned the post there by RRB Law LLP that you can always email Haryani at irrblaw.com.sg. First consultation is free of charge, but then as what Haryani has said, if your friend or somebody that you know owes you about $50, $100, please don't waste the first consultation lah. Don't waste, yeah. Only if like it's 10k and above. 10k can, right? 10k and above maybe can lah.
Of course, it's really up to you.
Yeah. Okay. Hadari, you are mute. You have to unmute.
I'm just saying that, I mean, 10, even if 1,000 also can, 700 also can, but I'm just saying weigh out the options and weigh out the how much you're getting versus how much you're paying for. Okay, just one very quick one. I think we have a lot of questions here, but I need you to just briefly explain to them. I mean, IRB law, we help do IOU
Yes.
between parties at a very, very low rate. I can't say it up here, lah, of course. So it's very important that you come and see a lawyer when you do up the IOU, because you'll never know what needs to be in there. People think it's just like, okay, I owe you this much. Okay, bye bye. But there are things to consider. Signatures should be witnessed and all that. So come and talk to us if you need that. We can help you with it. In fact, we can even help you. Let's say you supply food to a canteen. All this time is just okay lah. I WhatsApp you, you WhatsApp me. I pass it to you. Then after that, you pay me. It is actually very helpful if you just have like a 1 or 2 pager kind of simple form that can be like a contract between the supplier and whoever you're supplying it to safeguard yourself. And making that with us is gonna be not expensive. So do think about it. Just the same format you can keep giving to the people who have contractual agreements with you, or arrangements with you. So maybe Liu Yong,
Mm.
let them know what to look out for when they are signing an IOU.
Mm. Sure. Yes. Of course, the first thing that come to our mind will be the details of the parties. Okay, so make sure you get all this thing down. Then the next thing will be very clear on the repayment term. So how much is the principal, and when will be the first amount due, assuming it's an installment. Okay, then actually you can charge interest. Okay, there's nothing wrong with charging interest, but of course the interest rate must be something that the law allows. Okay, that is of course another thing why you should see a lawyer, because if you end up charging too high an interest rate, okay, it may be possible for your debtor to go and argue that, oh, this is unconscionable, things like that. Okay, so it's always safer to go through a lawyer. And of course, uh, at the end, when you sign, then I yes, in our course of work, we have seen many people who try to do it on their own, and some of this dispute even went all the way to court, because the defendant would then try to pick find fault with certain things, to try to say that no, this IOU is unenforceable. Okay, so yes, if you do it through a lawyer, then we will generally also try to engage another third party lawyer, so a neutral witness, to make sure that your IOUs is witnessed by a neutral third party lawyer. Okay, this as a form of evidence will, in my view, definitely add more weight, because then the debtor cannot deny that uh, he or she have read through everything and understand the implication before signing. So yes, to add on to Hani's point, this is why you should go through a lawyer if you want to. You're thinking of drafting an IOU, especially if the amount is quite substantial.
Yeah. Thank
Okay,
you so
I
much.
have
Okay, you
one
have a
question.
question, right?
Yeah,
Sure.
I have I have one question. Okay, because just now, because you were talking about if the person that you want to sue is a bankrupt. Okay, so this question has been sent over here via private message that asks whether will it be the same if happen that the other party is on a DRS, a debt repayment scheme. So is there a possibility that the debtors the creditors are able to actually claim from this person who is under DRS.
Uh, well, it's a bit like same but different. So, uh, okay, under DRS, so officially this person is not a bankrupt. Okay,
Mhm.
so your chances slightly higher. Okay, but what happens is that when this person goes under DRS, okay, there is already, so he's committed with the OA to pay this 5-year plan. Okay, so what you need to do currently is to go and also file a proof of debt. Okay, so your debt will be added to his 5 years plan. Okay, so he or she will to pay you as well. But again, I think most people don't know this, is that once this person goes under DRS, okay, then you are also quite unlikely to be able to recover fully. Okay, so the 5 years installment, usually the creditor is not expected to pay 100%, and it will be through a 5 years plan. So of course, then you need to weigh your pros and cons as well. I would say it's better than nothing. So once this person goes under DRS, yeah, you can engage a lawyer to help you find out more about how to file a proof of debt against your creditor who is under DRS now.
Mhm.
Thank you so much.
Okay. Yeah,
Yeah,
Yani, we also have a question on comment board, but maybe you want to ask a question from your side if you would like to share.
I have a lot here. I'm just looking at it.
Mm.
Okay, so I have a friend here who provided service to build his cabinet at home for $30,000,
Mm.
but there's nothing paid lah. So is there a difference if I go to small claims or if I go to like the court maybe?
Hmm. So, yes, first thing first, you need to check whether this claim falls under the jurisdiction of a small claim. Okay, 30,000 by right, the answer is no. Small claim only hears claim up to 20,000, and because small claim, yes, the fee is lower, so there are some restriction. The small claim will not entertain every claim, but the good thing is, you can go to small claim website. They provide quite a number of information to assess whether they will first take up your claim. Okay, so if it's 30,000, then both parties need to agree to raise the limit from 20 to 30. Okay, and of course, I would say, yeah, pros and cons again. Going through small claim, yes, you can do that. It's definitely cheaper. Then, but you need to do this on your own. For small claim, yeah, you also need to follow certain papers, etc. You need to appear before the referee, but before that, there will be mediation as well. And small claim, they don't allow lawyer. Okay, so no lawyer can represent you. Okay, so for such cases, if you go through the lawyer route, I would say, especially I would say when it comes to renovation, although it's very common, but I think many people don't really are not fully aware how complex it can get actually if you go to trial. So yeah, if you have a renovation claim, especially there are a lot of dispute, there are a lot of variation claim. So the contractor say that, oh no, you asked me to do this, now you're saying no, etc., or the work not done to my satisfaction. I would say before you approach small claim, maybe again sit down with your lawyer, get a lawyer. We have free consultation. That let us assess your claim first, and then before you make a decision whether you have to go through small claim or through a lawyer.
That's very good.
Mhm.
Thank you so much. I have this question that I think I can help you with lah.
Mm,
If I get a judgment, then if the other side don't want to pay, then I need to enforce the judgment. Isn't it not throwing money since there's no guarantee I will get my money back? I just now Liuying mentioned is if the person is not bankrupt and the person may have some money to pay slowly, there's a 50 chance, 50% chance. Of course, it's a case to case basis lah. That's what he mentioned just now.
mm,
So answer this question, Mr. Joe, I think you have to meet your lawyer, tell them the exact scenario, who these people are, how much is it, so that we can advise you further and for you to decide about it. That's one. Um, the other one, okay, no, the other one, I think we can do it a little bit later. Helmi, do you want to go on to your one before? There's three more questions with me, so maybe you can.
Okay, one of the questions that you have asked is actually a similar question. So one more question will be, I think it will be like quite common nowadays, especially with a lot of, it's more about weddings, okay, whereby there's a lot of cancellation due to the current COVID situation or this
mm,
thing. So the question that they ask is there a possibility that if there are some deposit payments but then they are not able to be refunded, is there any way for them to be they can recover all these payments that has been paid to them and then being
mm,
cancelled? Yeah, so this is how so I believe this person A actually have paid a certain amount or deposit to person B, but then due to
mm,
the cancellation unforeseen circumstances, then they
mm,
have to cancel everything, but then party A doesn't want to return anything.
mm.
So is there
Uh,
any, is that considered part of that recovery?
yes, it is. Okay, Helmi, thank you for the question. That's another very common question that we get these days. So the short answer is yes, that is also a debt. And I think there is of course, the government has passed the COVID-19 Temporary Measures Act, okay, but there seems to be quite a misconception that this means actually you cannot recover your deposit. That is not true. Okay, but of course, the whole idea of the this COVID-19 Act is of course government understand that a lot of business are affected. You most likely don't have the cash flow now if everybody start coming to you and request for the deposit back because you cannot perform, and you cannot perform is not really your fault as well because due to lockdown, things like that. So what this does is actually only postponing the recovery. Okay, so for certain, I would just stick to wedding since that was your question. Yes, for this kind of wedding banquet, it falls under one of these contract that is applicable under the COVID-19 Act. Okay, so if you have a deposit currently with the wedding planner, then currently you cannot sue. Okay, so you cannot sue this person in court. Okay, again, there are still quite a number of criteria you have to hit first. Okay, which I will not go into detail because it's really, it will take all day lah. If I have to explain about the COVID-19 Act. Okay, so you need to be aware of certain dates. When was the contract entered into, when is it due to be performed, etc. All these information are now very widely available online. Okay, and assuming that yes, your contract is applicable, so currently yes, you cannot sue the person, but what you can do is to file assessment with the Ministry of Law. Okay, so this assessor will then uh, act something like a mediator as well to see how party can resolve, and then maybe this assessor at the end of the assessment will say that, okay, look, yes, this refund you need to pay, but I understand currently you got no job, no business, so how much can you pay the refund slowly in installment? Yeah, things like that. So yeah, the short answer to your question is the deposit still can be recovered. That doesn't mean that it's gone. Just that it's a bit more, I would say, yes, it's a bit more troublesome now.
Okay, I
Thank you.
hope you have answered the questions that has been asked privately. Okay, maybe Haryani.
Yeah, I've got a couple more here. Just nice, it's already 9:23. Earlier you said that there should be evidence that the money is transferred by WhatsApp, PayLah, but can it be like something that they say is actually a past exchange or a past consideration for something? Could he use that as a defense? And is it the burden to prove whether the money is a loan or a gift?
Mm,
Who it fall onto, the person claiming or the person who is being, sued?
mm, mm, mm. Of course, the general rule is this is quite a technical term. So he who alleges must prove. So if you say that it's a gift, then it is up to you to prove. But yeah, we have seen, especially for girlfriend, boyfriend, the kind of loan. Yeah, this is quite a common defense. But I would say, yeah, my personal opinion is that it is not easy as well because, especially if the amount is very huge. Okay,
Yeah.
and it's very unlikely for uh, two maybe just long-term friends or what, especially when it was given to you during the time that your business was bad or whatever you need. I know that you needed money, so I give you this amount. So it is up to you to go and tell the court, to show to the court that no, when I give you this money, it was intended to be a gift. So of course, yes, uh, legally speaking, if this defendant can prove that it's a gift, then no, he or she doesn't have to pay back. But my personal opinion is that it's generally quite hard to run this kind of defense.
Thank you so much. We'll continue. Um, so if let's say I already sued the defender and then I get an order, then suddenly he die, then how?
Well,
Sway lah, that one sway. Sorry, huh? Mr. Yeah, it's best way lah you. Yeah,
mm,
Du Yong, but there is a way, right, Du Yong?
yes, there is a way. So the debt doesn't stop after death actually. So what you do right now is that for most people, after they pass on, their loved one will go and apply for grant of probate or grant of letters of administration. That is something we can assist as well. Then, so what happened is that this person assets, okay, will go under the estate of the yes. So the administrator of or the executor will step into the decision and manage his or her assets. So this pool of assets, okay, is still available to creditor. Okay, so right now you don't sue the person anymore, the deceased, because he or she no longer around, but you sue he or her estate. Okay, so it is still possible.
Okay, thank you. Yeah, so find out who the administrators are and all that. Another one, what happens if a borrower from a legal money lender, thank you, Mr. Georgette, from a legal money lender is now serving a sentence, or whether if he's in prison. So how can we recover the amount?
Uh, well, I think first we need to consider the practical aspect. Yes, legally speaking, you can still go and sue this person. You can serve the writ to prison. Okay, that can be done. But of course, I would say the first thing you should consider is this person is already in prison. Yeah, of course, it also depends on the situation why he or she is in prison, and you need to weigh up whether is it worth it to go and recover against this person. But yes, assuming you still want to go ahead, then you still can. As I mentioned, you just need to serve the writ all this on the person in prison.
Come and talk to us, Mr. Georgette, if you need to find out a bit more what your what are the causes of actions available to you. We are more than happy to give you a free consultation. I have wait. I know it's already 9:30, but let
No,
me.
no issue.
We can have a few more. Are you okay with it?
Of course, please, please.
What
Okay.
is the difference between engaging lawyers and debt collectors?
Oh wow.
Let me tell you something. I have experience, okay? Not that I owe anybody money, okay? I would like to tell you that. So I have experience with debt collectors. They kept saying that they are legal debt collectors. I actually saw it right in front of my eyes while I was, sometimes under the block, right? Like sometimes got ground level houses, so you're like parking under the block. I actually saw that once. I saw them like coming like gangsters like that, and they really look like gangster, okay, and then they speak like gangster. They knock on the door like as if the door want to be brought, no, want to be broken like that. And a very old auntie came out, and then he kept telling her, your name, your name, your name, your name is in this. Then I think she's quite blur about it. So it's not very pleasant for the person on the receiving end, but it doesn't make you look good either. And after a while, right, the banter was very vulgar, and it was not even, it was fun to see, but I worry for the auntie actually. And then later got some police came by and all that. So after that I had to go off. I don't know what happened. So, and I remember the gangster looking guy saying that we're legal debt collector, but the way is that like scary lah. So that's what I see personally, what I saw personally. So maybe Liuying want to continue the legal way.
Yes, sure. Of course, I really make no comments about the debt collector. If they can recover for you, then good for you. And of course, some of my clients like that. Some, of course, has feedback to me that they are not effective or what for whatever reason. And of course, just like Hani said, I would think the problem with debt collector is that you cannot control them. So
yeah,
Mm.
yeah.
Yeah.
you don't know what is going to happen, and especially if let's say you run a very reputable company, and I don't know what they're going to do. You have to live with this uncertainty that will your reputation get affected. But I would just point out the most obvious thing is that at the end of the day, a debt collector is not a lawyer. Okay, so they cannot help you to sue a person. They cannot help to make a person a bankrupt. Okay, so if what you are after is to ensure that when the bank is to affect the credibility, sorry, the credit rating, okay, of your debtor. That's what when you sue somebody, when you make a person bankrupt, okay, this person will find that he or she will have a problem getting personal loan or unsecured loan from banks anymore. Because when even HDB, when you want to buy your house or what, all these financial institutions will do a credit check. Okay, so when they do a credit check, they'll realize that this person currently being sued. Okay, so then it puts into question as to should I lend you the money? Why are you being sued? So that is another way of, in a sense, forcing the person to pay you because this person don't wants you to stop the suit uh, against him or her lah. So yeah, then a debt collector cannot help you do that, okay, because they cannot
Mm.
sue for you.
Thank you so
I
much.
see.
If there's no other question, I have one last one which was funny, but I just want to say it just for the fun of it. But do you have any question, Helmi?
So far, no, except for that, I think Liuying have already answered that. Can we lodge a
Ah,
police report to recover our debts? Lodge police
Uh,
report to recover. I think
you cannot
no.
recover a debt by lodging a report.
you
Maybe
cannot.
too tired. Ask. Still the one fed up. Lodge a report. Yeah.
I mean, if
So
it's for record purposes, I guess not. But I don't know. Luyong, maybe you want to explain this part because if I can share this
Mm, mm.
funny account
hmm.
of a very good friend, what she did was she lodged a police report against this vendor who have not been paying the supplies to her. And then this vendor
Hmm.
is doing stuff like, oh, I really did. Oh my god, I got the wrong account number. Oh, you didn't get it. Okay, let me go to the bank right now. Then she will show a check. Oh, the check is going in right now. Then after that, no money. Then right now, no money. So she fed up. My friend go to the police station and lodge a report. So when the police called this vendor, right, she got so scared that she paid everything.
Hmm.
She was scared,
Hmm.
so she paid
Okay.
everything. So in a way, that kind of work, but technically, can a when you make a police report, can that help recover your debt? That one, Liu Yong, please answer.
Okay, I will state the obvious. If you willingly lend somebody money, okay, so there's no cheating involved. This person did not tell you any lies or what for you to part with the money, okay, then generally lodging a police report in this scenario isn't going to help because there is no does not appear to be any criminal charges that can be established. So just like what Hani said, yeah, you can lodge it for report purposes. Maybe if the things go to trial, you can show the court, look, I even lodged a police report. This is how genuine the claim is. Okay, but other than that, I would say they are. It's a very neutral thing. So you can lodge, but it wouldn't really help you in recovery.
Yeah,
Hmm.
yeah.
Okay.
Um,
So
and
it may not help on the recovery. So I hope Liu Yong have already answered um, answered your question about lodging a police report to recover your debts. Okay, the time
Can
now
I
is
stop you there?
yeah.
Hami, sorry. Yes, Liuying said it technically it doesn't help recover your debt because there's no such thing as recovery. That is just a lodging of police report. But this is no way of him saying don't go and lodge. If you
Ah,
lodge, it will show that it's genuine. You see, it's genuine. So
mhm,
go ahead, lodge the report if you think that it's going to help you. If you think that could help when you go to your lawyers or to us. He's not saying don't. He's just saying that
mm,
in the all fairness of the technical word recovery and the
ah,
meaning of it, the police report does not have the objective or rather the ability to be used and like get your money back. I mean,
mhm,
the first instance that the first instance or the example that I gave you just now was because out of fear the person gave back my friend.
mm.
Leon, something funny. Somebody actually posted this and said, "Can you please ask him what gel you use?" And his
Uh,
hairstyle is very nice. It's so random. I said I'm not gonna ask that. Then he said, "Please, because really the hairstyle is nice." I think he likes like that. But if you have curly hair, I know the guy that asked me have curly hair. If you have curly hair, there's nothing I can do with about it. Just some secret, guys.
sure, sure, sure.
You want to
Okay,
respond to
so yeah, you want to respond to that question also?
Uh, I actually, the thing is that that's a good question because I really never go and notice what did I use. So yeah, it never occurred to me to actually really, I'm the kind of guy I just buy anything that's on the market. I don't really care. So I am very surprised. It's a it's a good surprise to hear that somebody likes my hairstyle. That has rarely been said to me. But thank you very much, whoever you are.
Yeah.
Thank you.
Well, I think that will be a nice closure about noticing about the hair gel that you are using, Yu Yong. And thank you very much to all our viewers out there who has been watching us right from 8:30. And for those of you who are not able to uh, watch us Facebook Live, you can always go back to our Facebook page to view the recorded version of this Facebook Live. Thank you very much, Haryani Othman, for coming on board to be our guest moderator. You have really helped a lot to really moderate all of the terms, the difficult terms that maybe most of us will get lost in between. And thank you, Liuying, for giving us your professional views about debt recovery. I hope that it have benefited the people who has been watching or maybe will be watching at a later time. So if you have any questions, okay, with regards to debt recovery, feel free to always go to IRB Law LLP Facebook page, website, or even you can email to Haryani at irblaw.com.sg. First consultation for these matters will be free of charge, and subsequent charges, okay, they will advise you. Okay, so but then the first consultation, that is the most important thing. If you need any help on any matters, just email Haryani at irblaw.com.sg. Okay, thank you very much.
TLC Podcast. Thank you, TLC Podcast, for having us.
Yes,
Yeah,
thank
thank
you for
you
having me,
for
Ami. Thank you so
thank you
much.
very much. Okay, you're welcome. Okay, it's nice to have both of you here. So with that, we are going to end with our TLC outro. Bye bye. See you next time.
Bye.
Everybody, good night.
Thank you for listening to Talk, Lepak, Chill. Do make sure to catch us on our next podcast episode. Lepak.